This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
October 24, 2001. 4 of Jackson's fellow Nuremberg prosecutors spoke at the Jackson Center. James Conway, Henry King, Bernie Meltzer, and Whitney Harris participated. This symposium was more than history revisited. It demonstrated that the Nuremberg principles remain relevant to the 21st century.
Ladies and gentlemen, without further ado, I am thrilled and honored to introduce Whitney R. Harris.
I would like to thank everyone that has been so kind to us, but to do so, we go through every one of the tables. In an action unprecedented in the history of the Supreme Court of the United States, Associate Justice Robert H. Jackson took leave of the court pursuant to an executive order of May 8, 1945, to accept the appointment by President Harry Truman as the representative of the United States and as its chief of counsel in preparing and prosecuting charges of atrocities and war crimes against such of the leaders of the European Axis powers and their principal agents and accessories as the United States may agree with any of the United Nations to bring to trial before an international military tribunal. Thus began a period of agonizing effort and brilliant achievement that caused Justice Jackson to conclude his 1954 introduction to Tyranny on Trial with these words. His manuscript teaches me that the hard months at Nuremberg were well spent in the most important, enduring, and constructive work of my life. That is why you're building this marvelous center for Justice Jackson to represent what he did in his life. The Second World War began on September 1, 1939, when German armed forces, on the orders of Adolf Hitler, the Führer of the Third Reich, smashed into Poland. It ended on May 8, 1945, with the unconditional surrender of Germany by Hitler's successor, Admiral Karl Dönitz. In this period of 5.5 years, 25 million soldiers and civilians were killed. Millions more were maimed and injured. 6 million Jews and other minorities were murdered or died in concentration and labor camps. Cities were bombed and burned, and property was destroyed in vast quantities. The staggering cost of Hitler's evil ambitions, supported and abetted by his allies and accomplices, cried out for retribution. On October 30, 1943, as we saw in the film, President Franklin Roosevelt, Prime Minister Winston Churchill, and Premier Joseph Stalin declared in the Moscow Declaration that German officers and men and members of the Nazi Party who were responsible for or took a consenting part in atrocities, massacres, or executions would be sent back to the countries in which their deeds had been committed in order that they might be judged and punished according to the laws of the liberated countries, and that others whose offenses had no particular geographical location would be punished by joint decision of the governments of the Allies. But no decision was reached as to whether such offenders would be punished by executive action or pursuant to the judicial process. In Britain, Lord Chancellor Simon and Prime Minister Churchill were of the opinion that leading war criminals should be disposed of by executive action, a view echoed in the United States by Secretary of the Treasury Henry Morgenthau, who proposed to President Roosevelt on September 6, 1944, that German arch criminals should be shot upon capture and identification. Secretary Morgenthau was opposed by Secretary of War Henry L. Stimson, who felt that leading Nazis should be brought to trial before an international military tribunal. Stimson's views ultimately prevailed in the United States. On January 22, 1945, a memorandum initialed by Stimson as Secretary of War, Edward R. Stettinius, Jr. as Secretary of State, and Francis Biddle as Attorney General, was presented to President Roosevelt as an aide-memoire in discussions on the punishment of Nazi war criminals at the forthcoming Yalta Conference in the Crimea. This Yalta Memorandum urged use of the judicial method against Nazi leaders, stating condemnation of these criminals after a trial would command maximum public support in our own times and receive the respect of history. The use of the judicial method will, in addition, make available for all mankind to study in future years an authentic record of Nazi crimes and criminality. After the Yalta Conference, President Roosevelt sent Judge Samuel Rosenman to Europe as his personal representative to obtain the agreement of the United Kingdom for the trial of war criminals in general conformity with the Yalta Memorandum. He was unable to persuade the British to the American position and was still in Europe when on April 12, President Roosevelt died at Warm Springs, Georgia. Upon his return to the United States, Judge Rosenman was retained at this assignment by President Harry Truman. On April 13, Associate Justice Robert H. Jackson delivered an address to the American Society of International Law in which he declared his personal support for the concept of a public trial of alleged war criminals, concluding with the following caveat: the ultimate principle is that you must put no man on trial under the form of judicial proceedings if you are not willing to see him freed if not proved guilty. If you are determined to execute a man in any case, there is no occasion for a trial. The world yields no respect to courts that are merely organized to convict. A few days after his speech to the American Society of International Law, Justice Jackson received a call from Judge Rosenman inquiring whether he would consider accepting the role of chief prosecutor for the United States in a trial of the leading Nazi war criminals. Justice Jackson responded to the inquiry by a memorandum to the President of April 29, in which he declared his willingness to prepare and present the case against war criminals to a United Nations military tribunal within the general framework of the Yalta Memorandum. He stressed the importance of proceeding promptly, suggesting that to some extent perfection might be sacrificed to expedition. Justice Jackson thought that the assignment might lead to his handling of the case on behalf of all the United Nations, but he emphasized the importance of undertaking at once his representation of the United States. The 1944-45 term of the Supreme Court was drawing to a close, and Justice Jackson believed that he could undertake this special assignment without prejudice to his judicial obligations. As it turned out, this service to his country kept Justice Jackson from the 1945-46 term of the court and probably cost him the Chief Justiceship of the United States. The task facing Justice Jackson upon receiving his official assignment as United States Chief of Counsel on May 8 was staggering. He was to bring to justice the leaders of the European Axis who were responsible for the deaths and devastation wrought by World War II. To this end, he had to obtain the agreement of the Allies to a military trial. He had to negotiate with them the organization, jurisdiction, and procedure of the tribunal. He had to join with them in the identification of the persons to be accused and to prepare suitable indictments. He had to find a site for the trial, see to the availability of a courtroom, prison, and other facilities for the trial. He had to supervise the housing and feeding of lawyers and others participating in the trial. And he had to find the members of his legal staff and personally conduct and direct the prosecution of the case in behalf of the United States. Think of it. No more frightening prospect or greater challenge was faced by any lawyer. With characteristic drive and enthusiasm, Justice Jackson set about promptly to overcome all obstacles and achieve a fair trial of the hated leaders of Nazi Germany. To gain the support of the Allies for the trial, Justice Jackson left for Europe on May 22nd. On the plane, he met Monsieur Georges Bidault and discussed plans for the trial with the French foreign minister. In Paris, he gained the promise of logistical and evidentiary support from General Dwight D. Eisenhower and other American military leaders. He found it necessary to use all of his persuasive powers in London to gain the agreement of Lord Chancellor Simon, Foreign Secretary Eden, and Attorney General Maxwell Fyfe to a judicial proceeding. On June 3rd, 2 days after Justice Jackson's return to Washington, the British ambassador informed the State Department that His Majesty's government had accepted in principle the American proposal as a basis for discussion by the representatives of the Allied governments. The United States, France, and Soviet Russia were invited to send representatives to London for conferences to begin on or about June 25th. The United States accepted at once, and Justice Jackson returned to London on June 19. The first formal meeting of negotiators took place in London on June 26, 1945. Prime Minister Churchill had appointed his Attorney General, Sir David Maxwell Fyfe, as the British representative. The London Agreement was adopted on August 8, 1945, establishing the charter for the International Military Tribunal for the just and prompt trial and punishment of the major war criminals of the European Axis. The tribunal was to consist of 4 members, each with an alternate. 1 member and 1 alternate were to be appointed by each of the original signatories. The presence of all 4 members, or the alternate for any absent member, was necessary to constitute a quorum. Decisions were to be by a majority, with the vote of the President chosen by the members of the tribunal deciding in case of ties, except that convictions and sentences required affirmative votes of at least 3 members. 3 categories of crime were declared within the jurisdiction of the tribunal: crimes against peace, initiating and waging wars of aggression, or in violation of treaties or conspiracy to that end; war crimes, violations of the laws and customs of war; and crimes against humanity, extermination or other inhumane treatment of civilian populations in connection with other crimes within the jurisdiction of the tribunal. Accomplices were declared responsible for all acts performed by any persons in execution of a common plan or conspiracy to commit the crimes as so specified. The holding of a high governmental office could not excuse liability or mitigate punishment. Acting pursuant to superior orders could not excuse liability, but might be heard in mitigation of punishment. Successful conclusion of the negotiations for the London Agreement was a personal triumph for Justice Jackson. All basic provisions of the American plan had been incorporated in the final draft of the Charter. The provisions of law set out in the Charter were binding upon the tribunal and provided the jurisdictional basis for the judgment. As the tribunal declared, the making of the Charter was the exercise of the sovereign legislative power by the countries to which the German Reich unconditionally surrendered, and the undoubted right of these countries to legislate for the occupied territories has been recognized by the civilized world. The Charter is not an arbitrary exercise of power on the part of the victorious nations, but in the view of the tribunal, as will be shown, it is the expression of international law existing at the time of its creation, and to that extent is itself a contribution to international law. The seat of the tribunal was fixed at Berlin, and it was there that the British member, Lord Geoffrey Lawrence, was elected president of the tribunal. Nuremberg was selected as a site of the trial, despite having been virtually demolished by Allied bombing and artillery fire, principally because of the availability in the suburb of Fürth of the Palace of Justice with an adjoining prison. Since Nuremberg was in the American zone of occupation, it became the responsibility of the Americans, under the direction of Justice Jackson, to prepare the site and make the necessary physical arrangements for the trial. A courtroom was constructed within the damaged courthouse, and facilities were provided for the tribunal, prosecution, and defense counsel and their staffs. A document center was set up and translations made of hundreds of captured documents. In order that the proceedings could be understood in the several languages of the participating nations and the witnesses, an instantaneous translation system was installed. Headphones were provided with controls enabling the listener to hear the proceedings in the language of his choice, and a bank of translators instantaneously translated all spoken words into the several languages used in the courtroom. Lights were provided at the lawyer's podium and the witness box to warn against speaking too rapidly for the translators. The logistics of the trial, including the housing and feeding of the personnel involved and the necessary security measures, were enormous. Evidence had to be found to support the broad charges of the indictment. In some cases, this involved literally digging up buried caches of incriminating documents. All this material had to be assembled, translated, evaluated, authenticated, and organized for presentation to the tribunal. Witnesses had to be identified, located in prisoner of war camps or other sites, transported to Nuremberg, and interrogated before being called to the stand. Photographs and films had to be found, authenticated, and prepared for reproduction for the tribunal. And the necessity for commencement of the trial without undue delay compounded these difficulties. As the time approached for a presentation of the American case, Justice Jackson was faced with a strategic decision of critical importance: whether to present the affirmative case primarily through the testimony of witnesses, supplemented with documentary proofs, or to offer essentially a case based upon captured German documents, supplemented with oral testimony. General William Donovan, Chief of the Office of Strategic Services, advocated the former approach, and Colonel Robert G. Story, Jackson's Executive Trial Counsel, the latter. Justice Jackson decided that the record would better stand the test of history if every effort were made to prove Nazi crimes through captured Nazi documents. General Donovan withdrew from the case, and the trial staff concentrated upon the preparation of briefs based upon written evidence. Justice Jackson's decision was vindicated. The trial proceeded without significant delay after commencement on November 20, 1945. The documentary record established incontrovertibly the crimes of the Hitler regime. The indictment charged 24 leading Nazis with crimes set out in the Charter, including as count 1, a common plan or conspiracy to commit all such crimes. Proof of this count was committed to the American prosecution team. The trial began on November 20, 1945, with the reading of the indictment. The next morning, the 20 defendants then present in court entered pleas of not guilty, then followed by Justice Jackson, one of the greatest forensic achievements in legal history, the opening statement for the United States of America. The privilege of opening the first trial in history for crimes against the peace of the world imposes a grave responsibility. The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. That four great nations flushed with victory and stung with injury stay the hand of vengeance and voluntarily submit their captive enemies to the judgment of the law is one of the most significant tributes that power has ever paid to reason. Jackson turned to the defendants in the dock. Merely as individuals, he said, their fate is of little consequence to the world. What makes this inquest significant is that these prisoners represent sinister influences that will lurk in the world long after their bodies have returned to dust. They are living symbols of racial hatreds, of terrorism and violence, and of the arrogance and cruelty of power. They are symbols of fierce nationalisms and of militarism, of intrigue and war-making, which have embroiled Europe generation after generation, crushing its manhood, destroying its homes, and impoverishing its life. They have so identified themselves with the philosophies they conceived and with the forces they directed that any tenderness to them is a victory and an encouragement to all the evils which are attached to their names. Civilization can afford no compromise with the social forces which would gain renewed strength if we deal ambiguously or indecisively with the men in whom those forces now precariously survive. He declared that what the defendants stood for would be patiently and temperately disclosed. We will give you undeniable proofs of incredible events. And he described the incalculable crimes of the Hitler regime, the fruits of the sinister forces that sit with these defendants in the prisoner's dock. Jackson acknowledged the question of credibility raised by the subservient status of the defendants. Unfortunately, he observed, the nature of these crimes is such that both prosecution and judgment must be by victor nations over vanquished foes. The worldwide scope of the aggressions carried out by these men has left but few real neutrals. Either the victors must judge the vanquished, or we must leave the defeated to judge themselves. After referring to the failure of the latter course at the end of World War I, he counseled, we must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our own lips as well. We must summon such detachment and intellectual integrity to our task that this trial will commend itself to posterity as fulfilling humanity's aspirations to do justice. Jackson observed that if these men are the first war leaders of a defeated nation to be prosecuted in the name of the law, they are also the first to be given a chance to plead for their lives in the name of the law. He conceded that they be given a presumption of innocence and that the prosecution must accept the burden of proving criminal acts and the responsibility of these defendants for their commission. And he added that the prosecution had no purpose to incriminate the whole German people. Indeed, he added, the German, no less than the non-German world, has accounts to settle with these defendants. In opening the discussion of the law of the case, Justice Jackson said, the charter of this tribunal evidences a faith that the law is not only to govern the conduct of little men, but that even rulers are, as Lord Chief Justice Coke put it to King James, under God and the law. He declared that the charter establishing the tribunal laid down principles of law which were binding upon it. The validity of the provisions of the charter is conclusive upon us all, whether we have accepted the duty of judging or of prosecuting under it, as well as upon the defendants, who can point to no other law which gives them a right to be heard at all. With respect to the charge of waging aggressive war, Justice Jackson pointed to the Kellogg-Briand Pact of 1928 and other international agreements outlawing war and branding aggressive war as criminal, and referred to the provisions of the Weimar Constitution that the generally accepted rules of international law are considered as binding integral parts of the law of the German Reich. It is true, he conceded, that we have no judicial precedent for the charter, but international law is more than a scholarly collection of abstract and immutable principles. It is an outgrowth of treaties and agreements between nations and of accepted customs. Yet every custom has its origin in some single act, and every agreement has to be initiated by the actions of some state. Unless we are prepared to abandon every principle of growth for international law, we cannot deny that our own day has the right to institute customs and to conclude agreements that will themselves become sources of a newer and strengthened international law. Justice Jackson recognized the inadequacy of juridical action alone to prevent future wars, but he nevertheless urged the importance of holding statesmen responsible to the law. And let me make clear, he added, that while this law is first applied against German aggressors, the law includes, and if it is to serve a useful purpose, it must condemn aggression by any other nations, including those which sit here now in judgment. This trial represents mankind's desperate effort to apply the discipline of the law to statesmen who have used their powers of state to attack the foundations of the world's peace and to commit aggressions against the rights of their neighbors. He concluded his address with this magnificent peroration: "No charity can disguise the fact that the forces which these defendants represent, the forces that would advantage and delight in their acquittal, are the darkest and most sinister forces in society. Dictatorship and oppression, malevolence and passion, militarism and lawlessness. By their fruits we best know them. Their acts have bathed the world in blood and set civilization back a century. They have subjected their European neighbors to every outrage and torture, every spoliation and deprivation that insolence, cruelty, and greed could inflict. They have brought the German people to the lowest pitch of wretchedness, from which they can entertain no hope of early deliverance. They have stirred hatreds and incited domestic violence on every continent. These are the things that stand in the dock shoulder to shoulder with these prisoners. The real complaining party at your bar is civilization. In all our countries, it is still a struggling and imperfect thing. It does not plead that the United States or any other country has been blameless of the conditions which made the German people easy victims to the blandishments and intimidations of the Nazi conspirators. But it points to the dreadful sequence of aggressions and crimes I have recited. It points to the weariness of flesh, the exhaustion of resources, and the destructiveness of all that was beautiful or useful in so much of the world, and to greater potentialities for destruction the days to come. It is not necessary, among the ruins of this ancient and beautiful city, with untold members of its civilian inhabitants still buried in its rubble, to argue the proposition that to start or wage an aggressive war has the moral qualities of the worst of crimes. The refuge of the defendants can be only their hope that international law will lag so far behind the moral sense of mankind that conduct which is crime in the moral sense must be regarded as innocent in law. Civilization asks whether law is so laggard as to be utterly helpless to deal with crimes of this magnitude by criminals of this order of importance. It does not expect that you can make war impossible. It does expect that your juridical action will put the forces of international law, its precepts, its prohibitions, and most of all its sanctions on the side of peace, so that men and women of good will in all countries may have leave to live by no man's leave underneath the law. Following the opening speech, Justice Jackson directed the presentation of evidence by the various members of his staff on the common plan, individual defendants, and indicted organizations. The British followed with evidence of the initiating and waging of wars in violation of international treaties, agreements, and assurances. The French offered proof of war crimes and crimes against humanity in the West, and the Soviets submitted evidence of war crimes and crimes against humanity in the East. At the conclusion of the prosecution's case, the defendants offered rebutting testimony, save in the instance of the Katyn Forest massacre involving the execution of 10,000 Polish officers and their mass burial in the Katyn Forest, which the Soviets had charged against the Germans, but which a spirited German defense had been committed by Soviet troops. The defendants did not deny the major crimes charged against the Hitler regime. It would have been extremely difficult for them to mount any telling defense to these crimes because most of the evidence of their commission had been derived from captured German documents. For the most part, therefore, the defendants sought to dissociate themselves from the worst of the Nazi crimes hoping that extenuating circumstances in their several cases would mitigate punishment. Hermann Wilhelm Goering sat in the first seat of the first row of the defendant's box. The tunic which he wore hung heavily about his body, for he had lost much weight after his capture. Drugs, which had become a ritual of his life, had been taken from him, and his mind had regained clarity. He, no longer a dilettante, he found again the audacity and cunning which had enabled him to rise to a position of highest authority in Germany, second only to the Führer himself. In his direct examination, Goering told of meeting Adolf Hitler in Munich in the days of the formation of the party, of his participation in the 1923 putsch, its failure and his flight abroad. He described his return to Germany and reassociations with Hitler, becoming an early Nazi, a member of the Reichstag. He acknowledged the Führer principle in which authority emanates from the top and responsibility rises from below. He admitted his support of the consolidation of the dictatorship and his personal efforts to strengthen the movement, not for the love of power, he claimed, but for the greatness of Germany. He supported and took a leading role in the absorption of Austria, but he testified that he opposed the invasion of Russia. He ended his testimony defiantly. And at this point, I should like to say the same words which one of our greatest, most important, and toughest opponents, the British Prime Minister Winston Churchill, used. In the struggle for life and death, there is in the end no legality. In his speeches and examinations, Justice Jackson was assisted by an aide at the desk adjoining the prosecutor's podium. Normally, he was assisted by his secretary, Mrs. Elsie Douglas, or his son, Lieutenant William E. Jackson. For the cross-examination of Goering, however, Justice Jackson asked me to serve at his side, and I was at his side throughout the cross-examination, assisting him with files and documents as it progressed. Confrontation of the number 2 Nazi by the leading prosecutor for the Allies was an event eagerly anticipated by the press. Apart from occasional bits of drama, as in the shattering testimony of Madame Valente Couturier describing her years at Auschwitz concentration camp, the trial had proceeded steadily under a mass of documents piling up evidence against the defendants. By March 18, 1946, when Jackson rose to cross-examine Goering, the media were hungering for the dramatic development which would bring the trial once again to the front pages of newspapers around the world. The cross-examination began as follows. Justice Jackson, you are perhaps aware that you are the only living man who can expound to us the true purposes of the Nazi Party and the inner workings of its leadership. Goering, I am perfectly aware of that. Jackson, yes, you from the very beginning, together with those who were associated with you, intended to overthrow and later did overthrow the Weimar Republic. Goering, that was, as far as I am concerned, my firm intention. Jackson, and upon coming to power, you immediately abolished parliamentary government in Germany. Goering, we found it to be no longer necessary. From this premise, Justice Jackson took Goering through the whole process of the seizure of power in Germany by Hitler and his co-conspirators with the object of consolidating the dictatorship, waging war, and persecuting and annihilating the Jews of Europe. Goering admitted that he sought to drive Jews out of the German economy from the inception of the tyranny. He did not deny that he proclaimed the anti-Jewish decrees at Nuremberg in 1935, the 1936 law prescribing the death penalty for transferring property abroad, the 1938 law punishing those who sought to hide ownership of Jewish enterprises, the decree of 1939 limiting the power of the courts to handle penalties against Jews, and a 1939 decree providing for the registration of Jewish property and requiring that disposal of Jewish enterprises be subject to permission by the authorities. He he said that in 1938, he signed a decree that Jews could no longer own stores, and answered, yes, those are all parts of decrees for the elimination of Jewry from economic life. Justice Jackson then turned to Goering's role in the elimination of the lives of German Jews. Jackson confronted Goering with his order of July 31 to Heinrich, chief of the security police and SD, directing Heinrich to make all necessary preparations for bringing about a complete solution of the Jewish question in the German sphere of influence in Europe. Heinrich responded by sending special task forces of the Gestapo and SD into the occupied Eastern territories, the Einsatzgruppen, with the mission of exterminating Jews in the field, while Himmler was ordering Rudolf Hirsch to establish the mass murder facility at Auschwitz, Poland. Extermination was the final solution of the Jewish question. When confronted with such evidence, on cross-examination, Goering realized his fate and lost his arrogance. Justice Jackson commenced his final address to the tribunal with a warning and a prophecy. It is common to think of our own time as standing at the apex of civilization, from which the deficiencies of preceding ages may patronizingly be viewed in the light of what is assumed to be progress. The reality is that in the long perspective of history, the present century will not hold an admirable position unless its second half is to redeem its first. These 20 years in the 20th century will be recorded in the Book of Years as one of the most bloody of all annals. 2 world wars have left a legacy of dead, which number more than all the armies engaged in any war that made ancient or medieval history. No half-century ever witnessed slaughtered on such a scale, such cruelties and inhumanities, such wholesale deportations of peoples into slavery, such annihilation of minorities. The terror of Torquemada pales before the Nazi Inquisition. These deeds are the overshadowing historical facts by which generations to come will remember this decade. If we cannot eliminate the causes and prevent the repetition of these barbaric events, it is not an irresponsible prophecy to say that this 20th century may yet succeed in bringing the doom of civilization. Justice Jackson reminded the tribunal that as early as 1923 in Mein Kampf, Hitler had declared his intention to attack neighboring states and seize their lands to be won with the power of a triumphant sword. He described the consolidation of political power after 1933 and the steps taken to prepare the nation for war, culminating in Goering's statement in 1936 that all measures are to be considered from the standpoint of an assured waging of war. By November 5, 1937, Jackson contended the plan to attack had begun to take definiteness as to time and victims. At the meeting on that day with his top military and political associates, Hitler declared that the question for Germany is where the greatest possible conquest could be made at the lowest possible cost. Hitler discussed plans for the invasion of Austria and Czechoslovakia, stating that the objective was the acquisition of additional living space in Europe, and concluding that the German question can be solved only by way of force. By May of 1939, Hitler confided to his co-conspirators his readiness to attack Poland at the first suitable opportunity. Jackson said that henceforward the Nazis prepared not as before for a war, but now for the war. He concluded, the dominant fact which stands out from all the thousands of pages of the record of this trial is that the central crime of the whole group of Nazi crimes, the attack on the peace of the world, was clearly and deliberately planned. After setting forth the position of each defendant in the conspiracy, Jackson responded to the argument that in an absolute dictatorship, only the dictator, in this case Adolf Hitler, can be held accountable because all others were bound to follow his supreme orders. This contention, Jackson pointed out, overlooks the fact that it was the defendants who placed Hitler in his position of absolute power and who supported and abetted his moves as dictatorship. The Führer principle of absolutism was itself a part of the common plan, as Goering has pointed out. The defendants may have become the slaves of a dictator, but he was their dictator. Jackson added, his guilt stands admitted by some defendants reluctantly, by some vindictively, but his guilt is the guilt of the whole dock and of every man in it. Justice Jackson concluded his summation with the following peroration. It is against such a background that these defendants now ask this tribunal to say that they are not guilty of planning, executing, or conspiring to commit this long list of crimes and wrongs. They stand before the record of this trial as blood-stained Gloucester stood by the body of his slain king. He begged of the widow as they beg of you, say I slew them not. And the queen replied, then say they were not slain, but dead they are. If you were to say of these men that they are not guilty, it would be as true to say that there has been no war, there are no slain, there has been no crime. No. That was for Justice Jackson. On the afternoon of October 1, 1946, the International Military Tribunal convened in final session. Every chair in the courtroom was occupied, except the 21 chairs in the prisoner's dock. The 4 judges and their alternates sat on the bench. Defense counsel faced them across the room. To the left were the 4 tables of the prosecuting staffs. I sat at the American prosecution table with Justice Jackson and his executive trial counsels, Robert Story and Tom Dodd. Behind us, members of the press and guests packed the visitors' gallery. The defendants were to be brought into the courtroom one at a time to hear the sentences pronounced against them. At 10 minutes before 3, the panel door in the back of the prisoner's dock slid silently open. The defendant, Hermann Goering, stepped out of the elevator which had brought him from the ground floor where the defendants waited. Goering put on a set of headphones which had been handed to him by one of the white helmeted American guards. The president of the tribunal began to speak. Goering signaled that he was unable to hear through the headphones, and there was an awkward delay while the technician sought to correct the difficulty. A new set of headphones was produced, and once again, Goering quietly awaited the words which were to decide his fate. Defendant Hermann Wilhelm Goering, on the counts of the indictment on which you have been convicted, the International Military Tribunal sentences you to death by hanging. The number 2 Nazi turned on his heel and passed through the panel door into the waiting elevator. The door closed, and there was a hum of whispered voices in the courtroom as those present awaited the arrival of the next defendant, Rudolf Hess. Hess, who had flown his Messerschmitt to England in a futile effort to persuade the British to abandon the fight with Germany, was sentenced to imprisonment for life. The other defendants appeared in turn and received their sentences. 12, including Martin Bormann, who had been tried in absentia, and my defendant, Ernst Kaltenbrunner, received death sentences. 3, Hans Fritsche, Halmer Schacht, and Franz von Papen, were acquitted, and the remaining 7 received varying terms of imprisonment. After delivering the sentences, the tribunal adjourned sine die. I had been appointed by Justice Jackson as his personal representative at the executions and was present in the Palace of Justice on the fateful night of October 15, 1946. Shortly before midnight, the electrifying word was released that Goering had cheated the hangman by taking poison while lying ostensibly asleep upon his bed in his cell. Death thus came to Goering by his own hand, as it had come to Hitler, Himmler, and Goebbels before him, even as the prison officer was walking to the cell block to give formal notice of the executions to take place that night. At 11 minutes past 1 o'clock in the morning of October 16, the white-faced former foreign minister Joachim von Ribbentrop stepped through the door into the execution chamber and faced the gallows on which he and the others condemned to die by the tribunal were to be hanged. His hands were unmanacled and bound behind him with a leather thong. Ribbentrop walked to the foot of the 13 steps leading to the gallows platform. He was asked to state his name and answered Joachim von Ribbentrop. Flanked by 2 guards and followed by the chaplain, he slowly mounted the stairs. On the platform, he saw the hangman and the noose of 13 coils, and the hangman's assistant with a black hood. He stood on the trap, and his feet were bound with a webbed army belt. Asked to state any last words, he said, "God protect Germany. God have mercy on my soul. My last wish is that German unity be maintained, that understanding between East and West be realized, and there be peace for the world." The trap was sprung and Ribbentrop died at 1:29. In the same way, each of the remaining defendants approached the scaffold and met the fate of common criminals. All, except the wordy Nazi philosopher Rosenberg, uttered final statements. After the executions, the body of each man was placed upon a simple wooden coffin. A tag with the name of the deceased was pinned to coat, shirt, or sweater. With the hangman's noose still about the neck, each hangman was photographed. The body of Hermann Goering was brought in and placed upon its box to be photographed with the others. In the early morning hours, 2 trucks carrying the 11 caskets left the prison compound at the Palace of Justice bound for a Munich crematory. There, during all of that day, the bodies were burned, one after the other. It was reported that in the evening, the 11 urns containing the ashes were taken away to be emptied into the river Isar. The dust of the dead was carried along in the currents of the stream to the Danube and thence to the sea. Thus ended the Hitler tyranny. The tyrant and his chief cohorts were gone. They had sought to achieve greatness in history, but they inscribed their names in sand, and clean waters fell upon the beach and washed them out. They had intended to establish a new order for Europe, but they built upon pillars of hate, and what they stood for could not stand. After Nuremberg, the prosecution of war criminals continued in other judicial forums. In the Far East, the Tokyo Military Tribunal conducted a trial of major Japanese war criminals. Several trials were initiated by United States military courts. 12 subsequent trials were conducted by 3-judge American tribunals in the Palace of Justice at Nuremberg. Denazification proceedings were initiated against thousands of former Nazis by German tribunals. And as the years passed, cases were brought against Nazi war criminals in various national courts. Foremost among these was the trial of Adolf Eichmann, the head of the Jewish section of the Gestapo. It was he who rounded up the Jews of Europe, arranging for them to be sent by rail to extermination centers, principally Auschwitz in the East. Eichmann escaped to Argentina after the war, where he lived under the pseudonym Ricardo Clement. In May 1960, 15 years after the end of the war, Eichmann was apprehended by Israeli agents and spirited to Israel, where he was brought to trial for his role in the extermination of European Jews. In the first televised trial of history, Eichmann testified from a bulletproof glass booth. His defense, that he merely carried out orders to bring European Jews to Auschwitz and other destinations in Poland, and was not responsible for what happened to them upon arrival, fell upon deaf ears. The man in the glass booth was convicted and executed for his role in the Nazi program of genocide. Shortly after the Nuremberg judgment was handed down, an international congress of lawyers met in Paris under the sponsorship of the Mouvement National Judiciaire Français. The Congress, which consisted of lawyers from 22 countries, including all of the prosecuting powers of the International Military Tribunal, called for the establishment of an international criminal court. Judge Henri Donadieu de Fabre, the French judge at the International Military Tribunal, proposed the following year that a criminal chamber of the International Court of Justice should be established to hear certain cases, and that, in addition, a permanent international criminal court should be established. On the day it adopted the Genocide Convention, December 18, 1948, the General Assembly of the United Nations requested the International Law Commission to undertake a study of a permanent international criminal court. Thus began a long period of international negotiations, culminating in a General Assembly resolution of December 17, 1996, calling for a diplomatic conference of plenipotentiaries to meet in 1998. The conference convened in Rome on June 15, 1998. Heinrich King and I participated as NGO delegates. Deliberations concluded on the following July 17th with the adoption of the statute for the International Criminal Court by a vote of 120 in favor to 7 against, with 23 abstentions. The United States voted against the treaty, along with Iran, Yemen, Qatar, Libya, Israel, and China. Treaty process requires that a treaty first be signed and later ratified by the number of nations prescribed to make the treaty operative. Under the Rome Statute, nations were given until the end of 2000 to sign the treaty, subject to subsequent ratification. On December 31, at the last moment, President Clinton directed our chief negotiator at Rome, Ambassador David Sheffer, to sign the treaty on behalf of the United States. This has been done, and our participation will become effective if and when the signed treaty is submitted to the Senate of the United States and is ratified by a 2/3 vote in the Senate. Israel likewise signed at the end of December 2000. The only non-signers of the Rome participants are Iran, Yemen, Qatar, Libya, and China. 60 nations must ratify the treaty before it becomes effective. 44 have ratified to date. On October 27, 2000, Germany, where Nazi leaders Justice Jackson prosecuted half a century ago, was the 23rd to ratify. I was present in the restored Reichstag building when the matter of ratification came before the Bundestag and was assigned a front row of the gallery. All the top leaders of the government were present, including Chancellor Gerhard Schroeder. The opening speech was by Minister of Justice Dalbler Malin, who stressed that the basic purpose of the treaty was to displace the law of force by the force of law. She noted that the treaty embraced the principle of complementarianism, meaning that so long as a competent national court dealt adequately with an international crime, the international court could not take jurisdiction. Representatives of all political parties addressed the Bundestag in support of the treaty. The concluding speech was by Vice Minister of Justice Vollmer, who introduced me from the floor, a great honor since no other persons were similarly recognized during the proceeding. Vollmer strongly supported the treaty and urged that it should not be weakened to gain the support of other nations. When the question of ratification was presented, the vote in favor of the treaty was 531 to none. It was unanimous. Germany, half a century after its Nazi leadership had been brought to trial before the ad hoc International Military Tribunal at Nuremberg, recognized and adopted as its own by unanimous vote of the Bundestag the basic legal principles of that historic trial, confirming the superiority of the rule of law over tyranny and despotism. Virtually all the world's leading nations, with the exception of the United States, Russia, and China, have signed and committed to ratify the treaty. In the United Kingdom, the bill was first introduced in the House of Lords, presented by Parliamentary Under-Secretary of State Baroness Scotland of Assault, who declared, "My Lords, I cannot overstate the historic importance of the creation of the International Military Court." To quote Kofi Annan, the Secretary General of the United Nations, on the subject, "People all over the world want to know that humanity can strike back, that whatever and whenever genocide, war crimes, or other such violations are committed, there is a court before which the criminal can be held to account, a court that puts an end to the global culture of immunity." The failure thus far of the United States to support the treaty arises out of a perceived need for complete freedom of action in our role as the primary defender of democracy in the world. But the basic purpose of the treaty is to punish those guilty of committing war crimes or crimes against humanity, not to impede peacekeeping. Even if an overly zealous prosecutor sought to charge a peacekeeping force with the commission of a war crime, he could not do so without the prior approval of the pretrial chamber of the court. Moreover, the Security Council has power to suspend an investigation or prosecution under Chapter 7 of the UN Charter. On September 11, 2001, America suffered extensive destruction of property and massive murder of civilians by a terrorist group. This was not an act of aggressive war, since wars are fought between states, but it would be a crime under Article 7 of the Rome Statute, which defines a crime against humanity as any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population. A, murder. Over 5,000 civilians were murdered by the World Trade Center terrorists. The victims were citizens of many nations. The United States has the right to bring the perpetrators of this crime to justice for the murder of Americans. If the International Criminal Court were functional, the criminals could be tried before that court for this horrendous crime against humanity, a crime not only against America, but against the civilized world. In Rome, in 1998 AD, the first statute for an international criminal court was enacted. It was the product of the efforts of many persons, beginning with the drafting of the Charter of the International Military Tribunal and the 1945-46 trial in Nuremberg under the inspired leadership of Justice Robert H. Jackson. But 50 years is just an hour in mankind's struggle for justice. Revisions of the Rome Treaty must be considered after 7 years of trial with its law and procedures. 700 years may pass before mankind is able to eliminate war and terrorism in the world and establish a system of universal justice. Rome was the beginning. The end may never come. For like Rome itself, the struggle for peace, law, and justice in the world is eternal.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as Chief Prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.